Hello, everyone. Welcome to our session, Synthetic Biology and Extremophiles. Our first speaker will be Kamil Muzyka. Kamil is PhD student at the Institute of Legal Sciences of the Polish Academy of Sciences. His project concerns legal aspects of mining, processing, and industrial use of raw materials, as well as patent aspect of synthetic and xenobiological organisms and self-replicating technologies. I just want to add that we had a slight change in the order of talks in our session. Kate Adamala and Niels Avershan, they're going to have their sessions, their talks switched, and the info is already updated in our program. Kamil, if you're ready,
Yes.
Please go ahead.
Okay, so hello everyone. My name is Kamil Muzyka, as Tomasz introduced me. My presentation will be on the self-replicating machines, void-hardened or actually void-adjusted organisms, and living space objects, which are the new challenges for space law and industrial astrobiology. And well, this might be a bit of a science fiction-y idea presented here, but as we would, I wish this presentation would work better. Yeah, as we will take a look at it. Well, those ideas actually aren't new to either. Well, they are new to international space law, but they are not new to futurism, futurology, and even space sciences. And as we can see here, this drawing of the self-growing and a self-replicating lunar factory is actually presented in one of NASA's papers called "The Advanced Automation for Space Mission," which was presented back in the 1980s in order to present the approach towards space resources and space manufacturing that would be more sustainable and replicating the mechanisms that are found within living systems. So any part of this factory would be able to be repaired and replicated using only the resources available on the moon. But yes, one first thing we need to ask ourselves from the space law perspective is what is a space object? Well, there isn't one definition of a space object. Mostly it's an artificial object or its components, which is a tautology in space law because a space object is a space object, as Virgilio Popper once pointed it out. But anyway, it's an artificial object that has been launched from Earth into outer space or landed and assembled on a celestial body. This is actually this derives from both the Outer Space Treaty, the Liability Convention, and the Registry Convention, although the United States actually uses the term space vehicles in their Title 51 regulations, although they had presented a concept to regulate the term space objects because they use the term space object, although they never define what a space object is. They mostly use a similar term, which was the space vehicle, but it was mostly designed. The term was designed for the shuttle, not let's say a space factory or a derivative of a space factory. So my point is, well, why are we talking about self-replicating? Well, self-replication is a overstretch, but it's an idea. They should be as sustainable as it can get because living organisms are sustainable as far as we know, but well, in the proper environment, of course. So, a space object possessing manufacturing capacities is a fairly mobile because every space object in space law is considered to be mobile. You don't have real estate in space law. That is the first thing you need to know about space law and space mining. You don't have land rights or real estate. Every object is mobile, and every activity can start and end with with space objects being replaced or being moved out of the area. So anyway, this consists either crewed stations or robotic stations. They have a space object possessing a manufacturing capacity is a object that can create either equipment or other objects or even refine fuel from either the local resources or the resources that are available through the logistic systems that are, for example, carried out from down the Earth's gravity well. Anyway, those aren't just single objects. Like, for example, we know the concept of von Neumann probe, but it's mostly either systems or a group of objects. And in some way, we need to keep in mind that those objects would also have the ability to manufacture, as we may call it, or farm living, living in creatures or organisms or even living components. But that will be cleared out in a bit. So one of the last things we need to know about those machines that what are the resources they are actually using? They are either purified substrate materials provided from in situ space resource utilization operations by these objects or other objects, or they actually use raw materials obtained from celestial bodies. They might also use the interstellar medium, but the interstellar medium much a isn't a for well isn't a material for construction. It's mostly for use as fuel, for example, using oxygen or hydrogen from the solar wind. Or the interstellar medium, especially hydrogen, and also recycled and cannibalized space debris and wrecks. So we actually are looking at objects that not only work as, for example, bacteria or plants in a macro scale, but they also can cannibalize parts from other space objects. Well, yes, these are machines that are able to create machines. In a sense, because this is a part of the idea. It's not only that the machines can replicate; it's one of their features, and this is very important. It's not only that they are, for example, the famous paperclip maximizers or the gray goo or the pink goo, as some futurists and science fiction authors call humans, but they are actually objects which can sustainably recreate themselves and repair themselves in this fashion. So anyway, uh, I created in space law in several of my papers the concept of the von Neumann doctrine. The von Neumann doctrine actually stems not basically from John von Neumann, but the concept that space objects, for example, space factories and their products, need to be secure in the legal sense. What I mean by that? Uh, I mean that on the basis of Article 7, Article 8 of the Outer Space Treaty, that spacefaring nations actually retain the control and jurisdiction over the objects that they have been launched or assembled or manufactured in space. Well, mostly launched and assembled. Space law doesn't define manufactured. In fact, there is a discussion whether the objects created by space factories or from resources mined from the moon, the asteroids, and so on, could be even treated as artificial space objects, even though the same material processing actually occurs on Earth. But well, space law has a difficult history that stems from the relations during the Cold War and the Apollo and Luna programs. Anyway, the von Neumann doctrine allows the state to retain control and jurisdiction over the progeny of its space objects, and even if it's a very far away progeny. That meaning, as presented here, it requires those objects and their components to be registered. Why the registry? Well, every space object needs to be registered, and this stems from two things. First of all, everybody wants to be in the clear of what is this space object, where does it come from, what's its purpose, and also who's the owner. Because if it doesn't have an owner, you cannot sue somebody for stealing your object or components, because well, they didn't know it was somebody's. Yeah, it's playing a fool in front of the court, but basically yes, that's how modern business and modern space operations can work in this environment. And on the other hand, we need to recall that if it's registered, the nation that is registered to is liable for any operation and harm that or harmful interference that this space object is causing. This is all. This is why we will actually go to a different part here. Formism. The formism meaning that well, we know that we actually have space robots. We know that we could actually create space robots which have a limited manufacturing and replicatable or repairing capacity. But can we create robots in the flesh? Well, yes, we can create robots in the living medium like the xenobots, which are derived from frog embryos, a special African frog, as far as I recall. Anyway, the idea is that okay, we've just made an assumptions on space objects, which are basically the same assumptions that are used in biopatents and biotechnological and synthetic biological patent law for space law. So can we do the same with treating organisms as, for example, space objects?
Kamil, we have 5
Well,
minutes.
basically, space law doesn't have the answer. There are many papers or even propositions for using microbes or even macroorganisms like fungi, lichen on the surface of asteroids, comets, or the moon, or even inside of space manufacturing facilities. But there isn't much talk in the space talk about how should they be regulated in the sense of in the meaning of space law. So if we actually carry some parts of the system, meaning the biopatent terms from the terms and well an understanding from patent law, and actually use them in international space law or national space laws or even intergovernmental agreements on space law, we can use the same idea in the case of well, not only well, not basically living space objects like the famous sci-fi example of the bioships, but there are concepts of engineered living materials which are actually being developed, well, developed and researched, even at NASA or even a European Space Agency, is actually researching the use of microbes in mining in outer space. That means that we would have to actually redefine what is a space object and how do we extend the jurisdiction and control over such living space objects from the for the same reasons that we actually discuss. Well, why I discussed them with robots, because for example, those lichen or microbes, even if they are synthetic or xenobiological microbes, they actually can do damage. If they are designed to, for example, chew through metal, they can actually even be well spread and land somewhere, on a foreign space object and inflict damage on the hull, or even infect astronauts and something like that. And the
We have
other part is that if it's not anywhere registered anywhere, and it is not recognized as a space object, nobody is probably prohibiting anyone. And I'm taking it seriously. Nobody's prohibiting anyone from stealing your or EVA-able microbes.
Kamil, please
Anyway, there
finish
is
soon.
also the idea that we need to recall that the issue of living space organisms in outer space is being discussed in the space resource circles, because we have the difference between the abiotic and non-living resources, but that's a topic for another discussion. What I am going to say that, first of all, if we're going to talk about void-hardened organisms and self-replicating machines in the case of law, we need to recall that, first of all, self-replicating technology are actually a very difficult thing to talk about. Well, first of all, is are those organisms a patentable subject matter? Mostly yes, but we need to say mostly because patent laws are harmonized globally under the TRIPS agreement, but they are not identical in every nation. For example, Australia doesn't allow patenting,
Kamil, can
doesn't
I,
allow patent protection of isolated biological
Kamil,
material, while
we have to
when
finish,
the
so
United
we will
States
have some
actually
time for discussion.
allows only patenting synthetic biological elements, and the European Union actually allows and Poland allows that isolated biological material can be a patentable subject matter. Also, there is the issue of patent exhaustion and importation, cannibalization of parts. Oh yes, I have to finish. Okay, 5 minutes,
Uh, two.
2 minutes. Okay, that's the last two slides. Okay, and also the idea of reconstruction and remanufacturing. Why it is actually being reasonable to discuss it with self-replicating or replicable or repairable robots, space station cobots, and so on. These actually take some inspiration from biotech patents. And also the idea of self-replication. Yes, that's mostly the most replicating technology doctrines in the U.S. patent law are based on the cases of the former company Monsanto versus Bowman, Monsanto versus Farmer, and also even the concept of innocent infringement, which I presented as AI induced. In normal patent law, it's a part of the self-replicating technology where the owner, the infringer, actually is implied that he is innocent because he didn't. He did nothing on purpose, but the self-replicating technology did it for itself, and he's liable for what happens on his field or on his space object that actually possesses some of those technologies, and what happens there. Also, there is the problem of extraterritoriality, where the patent law not only overlaps with international space law, but actually extends beyond the borders of space and national laws in space, meaning that they extend beyond the space objects. But mainly, what can we discuss here? But I don't have enough time to discuss it. Is the case of a temporary presence, which will be
Have
this
to
is
finish.
my end. So okay. So
Perfect,
thank you
Kamil. Thank you so
for your
much.
attention.
We have less than a minute for discussion. Thank you so much, because law is like space law is not a thing we think about every day. Can you just, in the 30 seconds, answer me the question: is space piracy even possible within the current law of space?
Yes, it is. Space piracy is very much possible, but not in the sense that Mark Watney cannot use some other agency's space object because he is an astronaut and he possesses a diplomatic status of the envoy of mankind. But piracy can is of course a viable reason that we have to rediscuss the idea of returning spacecraft because you can actually plunder a re-entry vehicle carrying some industrial equipment or for example industrial product.
Incredible. Thank you so much. We have to move on to Łukasz Kaczmarek talk now. Thank you, Kamil.